If police ever knock on your door because a neighbor, a family member, or your own spouse called in a wellness check, you need to understand exactly what the Supreme Court has said they can and cannot do to your firearms once they're standing on your porch, because the answer is more complicated than either side of the gun debate wants to admit. Years ago, the Supreme Court issued a unanimous decision, 9-0, striking down the idea that police can walk into your home and seize your legally owned guns without a warrant just because they've decided you might be a danger to yourself or someone else. Every single justice agreed on that core point. But here's what almost nobody explains clearly, and it's the reason this exact legal question keeps resurfacing in courtrooms across the country years later, with the Supreme Court repeatedly declining to step back in and settle the parts that were left open. I'm going to walk you through what that original decision actually said, what it deliberately left unresolved, why lower courts have kept fighting over the gap ever since, and why the court's continued refusal to revisit it matters just as much as the original ruling itself. Before we get into the specifics, if you want to understand your actual rights the moment a legal gray area like this gets tested again, subscribe and turn on notifications, because I track these Second Amendment and Fourth Amendment collisions the moment lower courts rule on them, not months later when the story has already been flattened into a slogan. Let's get into exactly what the court said and why it still matters. The case at the center of this story is Caniglia versus Strom, decided by the Supreme Court in May of 2021. The facts are worth knowing because they explain exactly why this case became the test everyone points to. A man in Cranston, Rhode Island got into an argument with his wife. During the argument, he placed an unloaded handgun on the dining room table and said something to the effect of, "Why don't you just shoot me and get it over with?" His wife left and spent the night at a hotel. The next morning, unable to reach him by phone, she called police and asked for a wellness check. Officers arrived, found the man on his porch, and believing he might be a danger to himself, arranged for him to go to the hospital for a psychiatric evaluation. According to the man's later account, officers told him they would not confiscate his firearms while he was gone. Once he left for the hospital, officers entered his home anyway and seized 2 handguns. He sued, arguing the warrantless search and seizure violated his Fourth Amendment rights. The lower court, the First Circuit Court of Appeals, sided with the police, ruling that a legal doctrine called the community caretaking exception, originally developed for police searching cars, extended to searching homes as well, when officers believed they were acting to protect someone's safety rather than investigate a crime. The second segment is what the Supreme Court actually decided when this reached them, and it's worth being precise here because the exact wording of a unanimous ruling like this carries enormous weight in every future case that cites it. Justice Clarence Thomas wrote the opinion for a unanimous court. The holding was narrow but firm. The community caretaking exception, first recognized in a 1973 case called Katie v. Dombrowski, involving a search of an impounded vehicle, does not extend to searches and seizures inside a person's home. Thomas wrote that the very core of the Fourth Amendment protects the right of a person to retreat into their own home and be free from unreasonable government intrusion, and that what is reasonable for a car parked on the side of a highway is fundamentally different from what is reasonable for a private residence. The court explicitly rejected the idea that police get some kind of broad, open-ended license to enter homes and remove property whenever they believe they're performing a caretaking function rather than a criminal investigation. If you are trying to understand the headline takeaway in one sentence, it's this: police cannot use good intentions alone as a substitute for a warrant when it comes to your home. The third segment is the part of this decision that almost every video and article covering it at the time either skipped entirely or badly oversimplified, and it is the single most important detail for understanding why this legal fight never actually ended. The Caniglia opinion was famously short, only a few pages, and the court went out of its way to say what it was not deciding. The opinion explicitly declined to address whether other established exceptions to the warrant requirement, like exigent circumstances, meaning an emergency where someone's safety is in immediate danger, might still justify a similar search under different facts. Justice Samuel Alito wrote a separate concurrence specifically to flag that the decision said nothing at all about the constitutionality of red flag laws, the state statutes that allow courts to order the temporary removal of firearms from someone found by a judge to pose a danger to themselves or others. Alito wrote plainly that this case does not involve a request to develop a body of law regarding those red flag statutes, and the court's decision should not be read to prejudge that question one way or the other. Justice Brett Kavanaugh wrote his own concurrence emphasizing that police still retain the ability to help in genuine emergencies through other established doctrines. So the actual scope of Caniglia is narrower than the celebratory headlines from 2021 suggested. It killed one specific legal theory, the community caretaking exception applied wholesale to homes. It did not resolve the much bigger and more commonly litigated question of what happens when a formal, judge-approved emergency risk protection order is involved, which is exactly the kind of order used every single day under the roughly 20 state red flag laws currently on the books. Here is a worked example that shows exactly why that distinction matters in practice. Imagine two nearly identical scenarios happening on the same night in two different states. In the first, police respond to a wellness check, decide on their own judgment that the resident's firearms should be removed for safety, and take them without ever going to a judge. Under Caniglia, that seizure is unconstitutional, full stop, regardless of how good the officer's intentions were. In the second scenario, a family member petitions a court that same evening. A judge reviews the petition and signs a temporary extreme risk protection order, authorizing removal of firearms pending a full hearing, and officers execute that judge-signed order. That second scenario looks almost identical from the outside, guns leaving a home the same night based on a safety concern, but it sits on completely different constitutional footing, because a judicial officer, not a police officer acting alone, made the call. That single procedural difference, whether a judge signed off before or after the firearms left the house, is the entire ballgame in how courts have treated these situations since 2021, and it is exactly the kind of technical distinction that gets lost when this story gets compressed into a headline. The fourth segment is what happened in the years after Caniglia, because this is where the story most people never hear actually unfolds. With the narrow scope of the ruling now established, lower courts across the country have spent years working through cases that test exactly where the line sits. Does Caniglia mean police need a warrant before removing firearms even in a genuine, fast-moving emergency where someone is expressing active suicidal intent in the moment? Most courts have said no, that true exigent circumstances, meaning an immediate, life-threatening situation, remain a separate and still valid basis for warrantless action, precisely because the Supreme Court explicitly said it wasn't deciding that question. Does Caniglia mean state red flag laws, which require a judge's signature before firearms can be temporarily removed, are constitutionally protected? Multiple state courts have upheld ERPO statutes after examining them under the historical framework the Supreme Court later established in a separate 2022 case, finding that because these laws generally require judicial sign-off rather than an officer's unilateral decision, they don't run into the same problem Caniglia identified. But the litigation is genuinely mixed depending on which state and which specific procedural safeguards are built into that state's law, and as of right now, the Supreme Court itself has never issued a direct ruling on whether red flag laws as a category are constitutional. That gap, left open on purpose in 2021, is still open today. In the years since Caniglia, a separate landmark decision in 2022, New York State Rifle and Pistol Association versus Bruin, reshaped how courts evaluate essentially every gun regulation in the country by requiring laws to be consistent with the nation's historical tradition of firearm regulation rather than simply balancing public safety against individual rights the way courts had for decades before. That new framework has been applied by lower courts specifically to red flag statutes in the years since, with some courts upholding ERPO laws under the historical tradition test by pointing to old surety laws and going armed laws from the founding era as sufficiently similar historical analogs, and other courts expressing skepticism that those old, narrow statutes really provide a close enough match to justify the modern, much broader practice of temporarily removing firearms from someone's home. That disagreement between courts applying the same legal test to the same category of law and reaching different conclusions is exactly the kind of split that eventually tends to force the Supreme Court's hand, but as of right now, it has not yet reached that point nationally. The fifth segment is the pattern worth understanding about how the Supreme Court has handled requests to step back into this area since Caniglia. Cases asking the court to clarify how far Fourth Amendment protection extends into gun seizure situations, and separate cases asking the court to weigh in more broadly on Second Amendment gun ownership restrictions, keep reaching the justices through the certiorari process, and the court keeps declining to take most of them up. As recently as January of 2026, the Supreme Court turned down several petitions in a single conference asking the justices to revisit gun rights questions, including challenges brought in cases like Zerka versus Bondi, Duarte versus United States, Collins versus Bondi, and Pierre versus United States, each one testing a different edge of federal firearms restrictions. Most of them centered on whether people with past felony convictions can be permanently barred from possessing a firearm at all. That is not one isolated denial. It reflects a consistent posture the court has held for years now, letting the narrow, specific holding of Caniglia stand exactly as written while declining, case after case, to expand or clarify it further, and leaving the harder, broader questions to percolate in the lower courts instead. When the Supreme Court denies a petition for review like this, it doesn't come with an explanation. There's no opinion, no vote count released, no reasoning attached, just a single line on an order list noting the petition was denied. The lower court ruling underneath simply stands, and everyone is left to guess why the justices passed. Some legal observers read this pattern as the court being cautious, waiting for a genuine circuit split, meaning different federal appeals courts reaching opposite conclusions on the same legal question before stepping in. Others read it as a quiet signal that the current court is comfortable leaving red flag laws and related gun seizure questions to individual states for now. It's worth noting that the justices do occasionally note a dissent from a cert denial, meaning one or more justices publicly object to the court's refusal to hear a case, which gives outside observers a rare window into internal disagreement. When that doesn't happen, as has largely been the case with the gun seizure and red flag question specifically, it typically means there wasn't enough internal appetite among the justices to take the case up at all. Not necessarily that the underlying legal question is considered settled or unimportant. The sixth segment is what the two sides of this debate actually argue, and both deserve to be presented fairly because this is one of the rare gun rights questions where the disagreement is genuinely about process and safeguards, rather than a flat yes or no on the underlying policy. Gun rights advocates focus heavily on due process. Their core concern is that many red flag orders can be issued on an emergency, temporary basis before the gun owner is ever notified or given a chance to respond, meaning someone can lose access to their firearms based on one side of a dispute being heard by a judge, with the full hearing and opportunity to contest it happening only afterward. They argue this ex parte process, meaning without the other party present, creates real risk of firearms being seized based on incomplete, mistaken, or even malicious information before the affected person ever gets their say. Gun safety advocates focus on the public safety side of the same coin, pointing to research suggesting that removing firearm access during an acute crisis, even temporarily, can meaningfully reduce the risk of both suicide and violence against others, and noting that most existing red flag statutes already require a judge's approval rather than allowing police to act entirely on their own judgment, which was precisely the flaw the Supreme Court identified and struck down in Caniglia itself. It's worth noting where both sides actually agree because it gets lost in the online shouting. Neither side is arguing that officers should be able to walk into a home and take guns purely on their own initiative with zero judicial oversight. The real disagreement is about timing, evidence standards, and how fast a full hearing has to happen after an emergency order goes into effect, not about whether courts should ever be involved at all. Gun rights organizations have generally pushed for reforms requiring the person facing an order to be notified and given an opportunity to respond before firearms are removed whenever possible, reserving the fastest, no-notice process for only the most extreme, immediate emergencies. Gun safety organizations have generally pushed back, arguing that requiring advance notice in every case defeats the entire purpose of an emergency order in situations where someone genuinely is in acute crisis, and that meaningful judicial review after the fact, combined with a prompt full hearing, provides sufficient protection without creating dangerous delay during the window when risk is highest. Neither position is unreasonable on its face, and reasonable people, including judges across different circuits, have landed in different places when weighing exactly how much advance process the Constitution actually requires before an emergency, judge-approved firearm removal can take effect. The seventh segment is what this actually means for you practically if you are a gun owner and someone ever calls police for a wellness check involving you or a family member. Know that Caniglia protects you specifically against police entering your home and seizing firearms purely on their own initiative, without a warrant and without a court order, based only on their own assessment that removing your guns would be a good idea. That protection is real, and it is the law of the land nationwide. But know equally clearly that this protection has real limits. If officers reasonably believe there is a genuine immediate emergency, meaning someone is in active danger right now, courts have generally still allowed warrantless action under the separate exigent circumstances doctrine that Caniglia explicitly left untouched. And if you live in one of the roughly 20 states with a red flag law on the books, a judge can still issue an order requiring you to surrender your firearms, sometimes before you're ever notified. And that order is a completely separate legal mechanism from the one Caniglia struck down. If you want to know exactly where your state stands, the concrete step is to search your state's name along with Extreme Risk Protection Order or Red Flag Law, find your state attorney general's official public safety page, and read the specific procedural protections written into your state's version of the law, because they vary significantly from state to state in terms of how much notice you get and how quickly a full hearing has to happen. The eighth segment, before we get to the bigger picture, is how differently individual states have chosen to build their own procedural safeguards into their red flag laws, because this variation is exactly what determines how much practical protection you actually have depending purely on your zip code. Some states allow only law enforcement or a prosecutor to petition for an order, keeping the process relatively narrow. Other states allow a much broader range of petitioners, including family members, roommates, or even co-workers, to initiate the process. Some states require a full hearing with the gun owner present within a matter of days after an emergency order is issued. Others allow that window to stretch longer. Some states explicitly require the firearms to be returned once the immediate risk has passed, and require destruction of the firearms only after a criminal conviction, protecting against permanent loss of property over a temporary crisis. Others handle that return process far less clearly. None of this variation was addressed by Caniglia, because Caniglia was about warrantless police action, not about judge-approved orders at all. It means two Americans experiencing an almost identical family crisis in two neighboring states can end up with meaningfully different levels of due process protection, different timelines for getting their day in court, and different paths back to legal firearm ownership once the crisis has passed, entirely because of which side of a state line they happen to live on. The ninth segment is why this pattern of unresolved gaps and repeated cert denials matters beyond just this one narrow legal question. It's a preview of how the Supreme Court tends to handle genuinely difficult constitutional collisions, cases where two real legitimate interests, individual property and due process rights on one side, public safety and crisis intervention on the other, are both pulling in opposite directions with no clean, obviously correct answer. Rather than writing one sweeping opinion that tries to resolve every possible fact pattern at once, the court in Caniglia deliberately wrote narrowly, decided only the specific question in front of it, and left the harder edge cases to work themselves out over years of lower court litigation before the justices step back in, if they ever do. That approach frustrates people on both sides who want a clean, final answer today. But it is also honestly how constitutional law in genuinely contested areas has always tended to develop, one narrow case at a time, with the full picture only becoming clear years later, once enough lower courts have weighed in and a real conflict forces the Supreme Court's hand. Let's step back and name the single thread running through this entire story. A unanimous Supreme Court decision protecting your home from warrantless firearm seizure sounds on its surface like a simple, settled, black and white rule. The reality is that the justices themselves were careful, deliberate, and explicit about how narrow that rule actually is, and every year since, lower courts and the Supreme Court's own repeated decisions not to intervene further have shown just how much of this area of law remains genuinely unsettled. That gap between the headline and the actual holding is exactly where confusion, and sometimes real legal jeopardy for both gun owners and the people trying to protect them, continues to live. It's also worth sitting honestly with why the court might be choosing to stay out of the harder questions rather than assuming it reflects indifference on either side. The justices who wrote and joined the narrow Caniglia opinion in 2021 came from every point on the ideological spectrum of that court, and all 9 agreed on the specific, limited question in front of them. That kind of unanimity on a narrow point, paired with a deliberate refusal to reach further, is often a sign that the justices themselves recognized how genuinely difficult the broader question is and preferred to let dozens of state legislatures and lower federal courts keep working through the practical details, the notice requirements, the hearing timelines, the evidentiary standards, before the Supreme Court commits the entire country to one single national rule. Whether you think that caution is wise or frustrating probably depends on which side of this debate you're already standing on, but it is worth recognizing as a deliberate choice rather than an accident or an oversight. If there's one thing worth taking from this breakdown, it's that a Supreme Court ruling is never just the headline it generates the day it's announced. It's the specific words in the opinion, the questions the justices explicitly decline to answer, and the years of quiet, unglamorous litigation that follow as everyone else tries to figure out exactly how far it reaches. You deserve to understand where the actual line sits, not just the version of the story that fits neatly into 30 seconds of outrage or celebration. Whether you own firearms yourself, have a family member who does, or simply want to understand how the Fourth and Second Amendments actually intersect in the moments that matter most, knowing the real boundaries of this ruling and the real gaps still sitting inside it puts you ahead of almost everyone still repeating the flattened version of this story from 4 years ago. If this helped you understand what Caniglia really does and does not protect, share it with a gun owner in your life who's never actually read past the headline, subscribe so you catch the next ruling the moment it drops, and I will see you in the next one.